students. So far I have explained section 122, communications during marriage, and section 123, affairs of state. Now I am teaching you section 124, official communications. You know, India, we have hundreds and hundreds and hundreds of governmental departments. We have thousands and thousands of officers, servants, administrators. There are communications between one officer, public servant, with another public servant. There are communications from one top officer to the lowest servant. The communications between the authorities is protected communication if the head of the department feels that the disclosure should not be made because it is going to create loss or the destruction of public peace, law and order, etc. When he thinks that if I disclose this information, it will create fear, it will create disorder in the society, then he shall not disclose that information. You know, gentle students, India has a democracy. There has to be transparency. And in this transparency, the so-called governmental servants, they want to maintain secrecy even in all the non-important matters. They will protect themselves, saying, no, this one is important, we don't disclose, we have the power under the Indian Evidence Act. So this section says only this much. If you, the head of the department, if you think that the disclosure is going to be dangerous to the society, harmful to the law and order, peace of the society, then you better don't disclose. But I would like to, they may ask you for short notes this one. You know, in this, there are some 4 cases to show how mean-minded the so-called officers. This case, Dilbagh, Roy, Jarry versus Union of India, 1974. He was a railway servant, an ordinary railway servant. And you know, he was not given the promotion and other benefits. He requested them why he was not given the promotion. What are the reasons? And you know, the so-called officers, they took the defense. It is all very secret. We have the protection. We need not disclose this. And the matter came before the Supreme Court. And you have to read the judgment. It says, Supreme Court says, you, the authorities, you take protection, you hide yourself behind the shields of law. Here is an ordinary railway servant, a poor servant. You made him to come to the Supreme Court of India. How much pain that he has suffered, how much money he has lost. To know the reasons, what are the reasons for his non-promotion. They said this is very, very bad. Every railway employee has the right to know the reasons, the justifications, the documents for not promoting him to the higher post. It is not top secret documents. Okay, like that, one more case. Madras Port Trust versus Himanshu International, 1974. In those days, there were no internet, There were no broadband, there were no mobile. Everything was only through communications, paper communications. And the communications, information was not reaching the workers. Today everything will be online. But in those days, you can imagine the darker days of India. There, the salary has to be paid according to the new scales, but it was not paid. And he asked, will you kindly disclose what is the new pay scales for me? And they said, no, it is a top secret. We are not going to disclose. So here in this case, the court said, fixing of salary, payment of salary, fixing of new scales is not a secret. It is an ordinary document. It has to be disclosed. In the same sense, one more simple case, IK Poolwal versus State of Rajasthan, 1988. You know, nowadays, 2020 today, 10th of May, 2020, and you know we have this corona effect. And today we are all having the information about various measures that has been taken by the municipality, by the corporation in protecting the sanitary measures, in protecting the common people of this country. So, in this case, he wanted to know from the municipality, from the government, what are the sanitary measures that you are taking for the protection of the health of the people? This is the question, that's all. What are the sanitary measures that you are taking for the protection of the people? And you know, these governmental officers, they said, no, this is top secret. We are not going to disclose. And the court said, what are the sanitary measures? How much money is spent there? What are the different methods, techniques adopted in maintaining the hygiene, maintaining the health of the people is an ordinary subject matter. It need not be, it has to be disclosed for the benefit of the common public. You cannot take the protection of hiding under section 124. One more case. Amarchand Bhutai versus Union of India, 1964. Today India is also a businessman. Government of India is also a businessman. It is entering into number of business transactions, business contracts with private persons, with other companies, with foreigners, etc. Now the question is, business contract, there will be terms and conditions that will be accepted by both the parties, the government and the non-government. So, the contractual document was not disclosed in this case, saying that government is having the superior power from disclosing the contractual terms and conditions. It is a secret. And the court said, any man can enter into a contract, and the contract is not related to the defense of India, and the contract is not related to the atomic power of India, the contract is not related to the satellite technology, then any ordinary business contract, terms and conditions, it is not having any special status. It has to be disclosed. It doesn't come under the official communication. So, for short notes, please write this much. Now we will go to section 125. Information as to crime. You know, gentle friends, you are the young India, you are the students of this country. the people, we do not support the government, we do not support the police department, whereas the Europeans support the police judiciary. Some of the foreign countries have developed a beautiful espionage system. The people are the pillars of espionage system in the European countries. The people will give information about any chances of crime or the happening of crime as early as possible to the authorities. The people have that psychology of passing the information first to the government. To bring that character into Indians, this section 125 has been written. It says, any people of India, if he gains an information about the chances of violation of law, about the crimes that may be committed in the coming days, or the happening of the crime today, the method of crime, the planning, if any people comes to know about it, they need not fear for anything. They have to come meet the concerned authorities, give the information. They can give the information to any concerned authorities, maybe revenue authorities, maybe police authorities, maybe the judiciary authorities. They can give the information. And here is a guarantee for those informers. Whatever information that you have given with a good mind, good intention, in helping the authority, in helping the law, the name and details of the informer shall be maintained secret. It should not be disclosed to any other person, because such a disclosure may be dangerous to the informers. So, here is a protection to those good-minded, social-minded, patriot-minded people who give information about the crimes to the authorities. Here is one case, R versus Johnson, 1989. I think all of you know narcotic drugs and psychotropic substances. Charas, ganja, heroin, brown sugar, LSD. Okay? Narcotic drugs are the enemy of the society. Narcotic drugs are going to destroy the youth of our country. So, law suppresses the transaction of narcotic drugs. In this case, Mr. Johnson, he was caught red-handed with 100% proof when he was dealing with the narcotic drugs. There was an informer. He has given the information to the authorities with a good mind. He allowed the police authorities. He gave his own premises to the police authorities for keeping an eye on this drug dealer. The police kept watch on him on all the 24 hours. This was a total secrecy. And the police were very successful in nabbing, in proving the offense. During the trial of this case, that offender asked the court, "You have found proof on me. Kindly disclose the name of the person who has given information about me." And you know, the court has rejected the appeal made by the offender to know the name of the informer, saying, "No, we are never going to disclose the names and details of the police informers or revenue informers or informers to the government. We have to protect their life, their families, so we are not going to disclose the details." So kindly, this is a general knowledge. Kindly, we have to make our country a beautiful country. Please pass this message. Bring the matter to the knowledge of the common people of this country. Tell the neighbors that we have to support the police department. We have to support the law. Okay? So here you may get short notes. We'll go to the next one. So we will continue with the chapter Professional Communication, section 126, 127, 128. I think all of you know, you are studying law and your profession, law profession. So you are called by the name advocate. You are called by the name barrister, attorney, pleader or vakil. You will register yourself with the Bar Council of India. You will have your own office and you will display your board. And the common people comes to your office with their cases, with their disputes, with their problems, with their pains. So this section says, the communications between an advocate and his client is a protected communication. It is a secret communication. It is a guarded communication. It shall not be disclosed to the outside world. Now, let us understand the word advocate. An advocate is considered as the friend of the society. He is the philosopher. Advocate is the troubleshooter. Advocate is the peacemaker. Advocate is a person of law. Advocate has a duty to protect his clients. Advocate must always think about guarding, protecting his clients. So, this section says, communications between an advocate and a client is a highly guarded communication, and the communication should not be disclosed to the other persons. But remember, when we will say that the communication it develops between the advocate and the client, first what will happen? The people with their problems, they will enter the office of the advocate, and there they must find a place that they must take the appointment, and that advocate must have time to listen. I'm using the word listen very carefully, with lot of patience. He must listen to the problem of the clients. He must be very cool person with lot of patience. He must create confidence. He must create trust in the mind of the clients so that they can tell the truth openly, fully, completely to the advocate. And these sections says the advocate may accept, may promise the person, I'm going to protect you, I'm going to fight your case, I'm going to guard you. Then there is a form called Wakalat form. There is a form called Wakalat form. And the advocate will give the form to the client saying that you please appoint me as your advocate, and then you kindly sign this and give it to me. So there, that person, he will sign his signature with the name of the advocate, and that is called Wakalat Nama. That is the letter of appointment of a person as an advocate to fight in favor of him in the court of law. When the moment the Wakalat form is filled and submitted to the advocate, there arises the relationship between advocate and the client. So this relationship is protected under section 126. This 127, Advocate's Office. In an advocate's office, you will find junior advocates, you will find a typist, or you will find a stenographer, you will find an office boy, you will find a watchman or a security man. So many persons are there in a good advocate's office. And this section says, all the persons working in the advocate's office have the duty to maintain secrecy. Whoever comes to the office, either to seek information, seek advice, or either to deliver the cases to the advocate, whatever communication that they are going to make to the advocate, none of the persons who are sitting there related to that office shall disclose this matter with any outside world. They are all protected communications. Okay, so what you can conclude now? The persons may come either to seek advices from the advocates, or the persons may appoint that advocate as their advocate to fight on behalf of them. Whatever communication that has been presented in the office shall be maintained secrecy. It should not be disclosed anywhere. It is a protected communication. You know, advocacy is one of the noble profession in this world. And unfortunately in our country, it do not have the desired place. Whereas in Europe, in Africa, advocacy is the first place of recognition. In the United States of America, advocacy is the first place of recognition. Very unfortunate in India, we do not have that desired position. Okay friends, now here is, I'd like to give a case, Roshan versus Bleen. Fact is very simple. You can easily remember the fact. An advocate has taken the case and that party has signed the Vakalatnama, and the advocate has promised, yes, I will fight for you. After the taking of the case, the opposite party made a phone call to this advocate saying, how can you take this? How can you take the case on behalf of this person? I have committed this many number of crimes. So he started explaining what all his power, what are the crime that he has done. Every detail he gave to the advocate. Advocate memorized all that and he passed the information to the authorities. Now the question is it a lawful disclosure of the information or not? Is it lawful disclosure or not? Whether this disclosure, is it protected under this professional communication or not? The disclosure of information by the advocate was challenged. And the court said, this professional communication is applicable only between the advocate and the client. Advocate and the party who comes to his office to secure, to get the advice, lawful advice. Only that persons have this protection. If an opposite party of the case comes and gives information about his crimes to the advocate, who is no way connected to him, there is no question of advocate and client relationship, then this protection is not available. Advocate is free to disclose the matter to the authorities. Okay, so remember this simple fact. Now exceptions are there. Exception says, in the following circumstances, the advocate is having the power to disclose the information to the authorities or to anyone. First point, communication made to the advocate in furtherance of crimes. Communication made to the advocate in further or furtherance of crimes. Modernity, modern people, modern thinking. Nowadays, there are people, arrogant people. They will come to the office of the advocate. They will tell, "See, Mr. Advocate, I want to give my case to you. For that you have to wait. I have decided to commit a murder, or I have decided to cheat a person. Will you please prepare a fraudulent sale deed for me? Will you please give me an idea how I can commit a murder? Or, I want to cheat a bank. Tell me, what is the easy method of cheating a bank?" So, some people comes to the advocate's office and securing the information about the commission of future crimes. In CRPC, there is a duty imposed on the people. If you get any information about the crimes, the future crimes, you have the duty to prevent it. Pass the information to the authorities. So, when any such person comes to the advocate's office requesting the advocates to give the tricks or the methods for the commission of the crimes, then immediately the advocate, he can pass the information to the concerned authorities. Such information is not a privileged information. It has to be disclosed because the society has to be maintained with peace. There should not be crimes. Prevention of crime is the object of the law. Right? Now we will go to the second one. Consider one Mr. Young man, a 28, 29-year-old man, comes to the office of an advocate and tells him, "Sir, will you please take my case? Will you fight my case?" And the advocate has asked him, "What is your case? What you have done?" And that man says, "Sir, I have cheated, sir. I have cheated to this much, and I am having that passbook, sir. Yes, sir, I have cheated this much of money." And the advocate has asked him, "Oh, kindly give me that passbook. I want to see how much." So he has seen that cheating, this much of amount of money. Advocate agree, "Don't worry, I will help you. I'll protect you. I'll take your case." The case has been taken and the case was going on. The civil cases, it will take so many months, sometimes years. When the case is going on, I think within 6 months or 7 months, the advocate came to know through someone that his client has cheated one more person. That his client has cheated one more person. So, the client has not disclosed the new cheatings, new crimes committed by him to the advocate. So, when an advocate comes to know about the new crimes committed by his clients in the course of appointment, in the course of relationship of advocate and client. Such information the advocate can pass it on to the authorities. Now, the third point, waiver of privilege by the party, by the client. This is not in practical world. No client will give the power to the advocate to disclose this matter to the opposite party or to the police or to the judge. No, they don't give it in writing. No. So this point says, for your writing in the exam, you write this much. Whenever a client gives it in writing to the advocate, the permission, the authority to disclose all the communications made to him, then that advocate, having the written permission, the advocate can disclose all the communications made to him by his own client. Go to the fourth one. Disclosure of evidence of communication between the advocate and the client by third persons, by strangers, by outsiders. See, young students, if you become an advocate in your life, keep it in mind this point, fourth point. That is, if you commence an advocate's office, you must do it systematically. You must have a chamber called soundproof chamber, so that in that chamber only you and your client can sit and discuss the matter, and the discussion should not go out of that room, of that chamber, because in an advocate's office there are so many outsiders who are sitting to take the consultancy of the advocates. Who knows? They may become the force of your client. So, if you don't have these soundproof chambers, then your client will sit with you in the presence of all other people. Then he will disclose his problem to you, and the problem will be known to the other person, and such other person, we call them as third persons. They may listen, they may hear, and they may come and give the evidence against your old client. Law gives such an opportunity to the strangers to give such evidences. So, when you complete your LLB, if you are interested, kindly keep this in mind. Have a beautiful, a small, even though it is a small, a closed soundproof chamber. Right? Yes. Go to the next point, that is the fifth point. When an advocate can disclose the information passed by his clients to the outside world, to the authorities. There are sincere advocates, there are sincere clients, and also vice versa. The relationship between an advocate and client must be purely professional. It should not enter into the privacy of each other. They must maintain the safe distance. Some advocates or some clients may misuse the relationship, which may lead to the quarrel between the advocate and the client. So the quarrel, it may reach the court, and the advocate has to protect himself in the court of law from the complaint of the client. There, that is the civil suit or the criminal suit, criminal case between the advocate and the client. There, the advocate is having the right to disclose all the information passed to him by his client. This should not happen. You, the young India, maintain this country beautifully. Become good advocates. Don't become bad advocates. Okay, young persons? This much you write in your examination. This is very, very important topic for your examination. This much is enough for today. Thank you for your listening.